very bright. Thanks, guys, for being here, and thanks for having me and inviting me along. As Paul said, I'm a lawyer and I work with EDO New South Wales. We're a community legal centre and we specialise in public interest environmental law. It's been a really interesting... I've been with EDO for the last 7 years. I'm currently the acting principal solicitor, so I'm mostly based in Sydney at the moment. And we've been having some really interesting times in the last couple of years. We have been, the sort of proliferation of coal mining in New South Wales has been an area now that I think the community has spoken and said that, and when I say the community, I mean, friends far and wide, and perhaps people that haven't normally or traditionally been characterised as protesters, and have decided that they've had enough and they're standing up, trying to protect their country or the country that they're living and working on, and particularly in our western regions and around the Hunter Valley, where some of the biggest threats for coal mining is. And of course, as Dean mentioned, the rise in the coal seam gas industry has made, has woken up or enlivened a lot of people who were happily sleeping in some of the rural parts of New South Wales. So our work in the last few years has become extremely interesting. We've been, a lot of our clients, so the sort of matters we work on are those kind of larger public interest type environmental matters. And it's been, as I say, it's been a really interesting time. We've been working with members of the community we've perhaps never worked with before. We've perhaps worked with people like Dean and Paul and others for the last 26, 27 years, along with others, of course. But in the more recent times, we're certainly working with people that we haven't worked with before. And so what's happened very interestingly in our world is that it's probably going back over 12 months now, when the current New South Wales government was elected, there was clearly some pressure placed on the New South Wales government about getting rid of our organisation. In fact, it came out and was made very clearly that the New South Wales Minerals Council and the New South Wales Coal Association had written to the Premier and suggested that EDO, was perhaps being a bit of a menace, because what we were doing is people were coming to us and saying, what can we do? And, we've got a massive coal expansion of a few different coal mines, and it's happening at a time now when people are well and truly switched on that where we need to be heading is towards a renewable energy future, and not expanding and certainly not creating new coal mines in New South Wales. And so a number of client groups came to us and we looked at the law and we said, okay, well, we still have some appeal rights here, or you guys still have some appeal rights, and we've been in and out of the courts for the last couple of years. One of the things that happened quite remarkably very recently was one particular case, which was the Warkworth mine. This case, and I'll kind of keep my talk to this case, just to give you an example of where things are up to on this front. The Warkworth case was a massive proposal for a big coal expansion down near a little town called Bulga, just down in the Hunter Valley. The community there got quite active, and again, very... a lot of older, more traditional rural landholders and farmers got together, realised that they had some limited opportunities to protest against a big coal company, but ultimately needed to look at this in terms of could it go through the courts, and could they challenge the development consent that the New South Wales government had currently had given earlier this year. Last year now. These cases take a long time to come to the end. So a few months ago, we got a decision from the New South Wales Land Environment Court after 14 days of hearing about the merits of this coal mine, about the endangered ecological communities that are on the brink of extinction, that this coal mine was going to take some of the last of, perhaps 80% of the remaining of this extremely rare endemic endangered ecological community. The Chief Judge of New South Wales at the Land Environment Court in New South Wales said, in this case, I'm going to overturn the consent of the New South Wales government, and we're refusing this project, and wrote a very, very large judgment on the merits and why, at this point in time, we would refuse that kind of development. It's one of the first times the court has overturned something so large as a coal mine development. And of course now I'm currently in the Court of Appeal because the company's appealing that judgment, and we've got a massive appeal ahead of us. So the threats that the EDO has experienced for that kind of litigation is the Coal Association, the Coal Association and the New South Wales Minerals Council wrote to the New South Wales government and said, do something about the EDO. Very interestingly, the government did do something about the EDO. So it's reduced our funding significantly. Our funding didn't come primarily from the New South Wales government, but the Attorney General had a concurrence role in relation to our funding. I won't go into the detail of where we get our funding from. But very, very seriously, it was an affront on the service that we provide to New South Wales. We're the only environmental law experts in New South Wales that is accessible to the community, either on a pro bono service or at a significantly reduced rate service. So it is very interesting at the moment that, you know, even as Paul referred to as the defenders of the defenders, and I'll just talk in a minute just a tiny bit about some of that work we do, that it came to a point, and it's continuing, that we in fact need defending as well. And what's been tremendous in the last few months is that much of the New South Wales community that we have interacted with, including some of our farmer friends way out west, irrigators, cotton farmers, etc., has come to our aid, and that community has written to the government and it has shouted to the government and said, hang on a minute, this is an affront on our democracy. When we as a community can't access the courts of New South Wales reasonably in order to have an independent umpire rather than our politics of the day have a say on our environment and make important decisions about our environment, then something in democracy is going terribly wrong and perhaps rapidly heading backwards as opposed to progressing and evolving the discussions that we have as a democracy. So one of the things, then I'll finish on this, one of the things I've been really fortunate to do in some of my work as a lawyer, even before I worked at EDO and at times when I've worked at EDO, is I've had the privilege of representing and working with people who have gone a really, really long personal journey to protect the environment. And I'm talking about people who have put their life on the line to protect a particular piece of the environment, whether it be their local environment or in relation to an issue that's broadly offending the environment that they care so much about. And a couple of years ago, I was running an appeal. I had 79 people who I was defending. I defended them in the local court in Muswellbrook, and they were participating in what's called Climate Camp. It was a big national event, and it was a few days of getting together and people really, really talking about climate change and the impacts that climate change is going to have on our environment. Anyway, on the last day of that event, there was an organised protest and a direct action, and some people ended up brushing up against the law and very peacefully exercising their rights to protest and exercising their right to engage in civil disobedience, which in fact led to a breach of the law. And the law, it was a trespass type law, so no, in terms of what the seriousness of an offence, we're not talking about a very serious offence. So those 79 people were basically pleading guilty. They were saying, yeah, look, that's what we did. We did what we did. We sat on the train tracks of the coal loading train, and we wanted to make our statement to not just all of Australia, to the entire world, to say we really want to change the way things are happening. We have to stop operating the way we are if we're to protect the planet and future generations from the very serious impacts of climate change. The more I was engaging with the discussions that you have in a defence of somebody, the more you really start to understand, where this motivation comes from and what it is in a person. And you realise very, very quickly there's very little self-motivation involved. In fact, the entire action is an incredibly selfless and often at a massive cost to the individual, their family and the people they interact with. So we pleaded guilty in the local court. But unfortunately, it didn't quite go as I had planned as the lawyer representing these people. And instead of getting a Section 10 for these people, which means basically that they've accepted that they did what they did, but there's no punishment and the charges are dismissed against them, the magistrate said, oh, well, they all get a fine and off they go. Now, what then happened and what we realised was that, we were dealing with people who are just not people who have a criminal record, or what they did just did not warrant having a criminal record. And I mean that in terms of the law, because the law does allow certain leniencies in terms of penalty. So anyway, we went off. 49 of those people decided that they wanted to appeal, and we went to the district court. And then we went and we were heard by a judge of the district court. And what was incredible was we were able to make submissions to the judge about the people involved in the protest and really where they were coming from. And what was really tremendous that day is the judge made very clear in his ruling, where he dismissed all the charges, or the majority of the charges, to the extent of the power that he had to exercise. And he said that what was really clear about that day was that all of those people involved were incredibly selfless, inspired, community-motivated individuals that just want to do good for this planet. So sometimes, I suppose my message is sometimes, while the one place, that isn't the most understanding of our environment is the courts, they are, for better or worse, a part of the system that we have, that we need to be able to access them in order to be able to achieve or not achieve environmental justice. And when I say not achieve, sometimes we do lose, and in fact we've lost quite a lot of cases, but losing some of those cases is what we need in order to show how clear it is that we might need law reform and law change. So what I'm saying is, as much as it can be really difficult for people to understand the role of the courts and the role of law, it actually does have a place, and to ignore that place is something that in terms of environmental protection, it won't do any service. So there is a place for the courts. Some good things do come out of the courts, and at the end of the day, when bad things come out of the courts, or as we assess them as being bad things, or not the best thing for the environment, it's an indication for us that we need to work harder, and perhaps in different ways, to work very hard for that change. All right, I'll finish at that.